the gun jumping advice and things like that that's up there has been very helpful, not only to practitioners, I think, but also it helps us to explain to our clients why this is important when we're actually seeing stuff come up there and in the CCB's videos and all of the other media that various other competition authorities have put out as well. So really great to see. Dina, Gönenç, any comments on these agency initiatives?
Hi, Gönenç here. I think these agency initiatives are very inspiring also for private entities, because there is sometimes some form of apathy or lethargy in the sense that, some agencies feel like your only reward of these compliance programs are your lack of any infringement, basically, and that they're not that interested in whether you have this kind of a program or not. If you haven't infringed competition laws, kudos to you. If you have, then, I'm sorry, but then your compliance program must have not worked. And these kinds of agency initiatives basically are inspiring private entities in the sense that then they understand that agencies do understand how complex and difficult these things are, and that they're not taking a black and white kind of an approach toward these things. So I think it's quite wonderful that especially agencies that are known to be so sophisticated and leading in the competition law world are taking these views and are deploying their resources into this.
So let's turn now to developing the culture of compliance within an organization. It's really an aspect of corporate integrity, I think, as much as kind of avoiding violating particular laws. Gönenç, what are some of the ways or some of the issues around developing a culture of compliance in a company that you've seen?
So it was interesting to observe that in the voting, what we would call as tone at the top came last. There was a particular choice there, the CEO giving messages of compliance being important and all, and it came last. It is understandable because there were some overarching, more important matters in there. It kind of, when you pose them as mutually exclusive, maybe you would want people to know what compliance is in the form of training, and you wouldn't care so much as to what the CEO says.
That was a very unfair poll, I have to say, I do apologize for that.
Yeah. But it is somewhat true that it is becoming a bit passé that tone at the top does the trick. It is more and more becoming apparent that you cannot do anything without the tone at the top, that's for sure. If you don't have traction, then it's just not going to penetrate. But the tone at the top in an isolated fashion basically means that people on the field, people who are dealing with the antitrust risk on a daily basis, they kind of profile the people at the top as having to speak that kind of language. Yeah, sure, this is shareholders' language. Once I get there, I will be speaking that language as well. But for now, numbers will need to be performed, and I'm in the battle zone. So, you kind of find yourself in that you can't handle the truth kind of an issue. And to deal with it, I think the corporate culture will need to be penetrated. And that basically means that one has to be sincere about diverging interests and address all of these diverging interests also in the form of what do we call performance. What kind of performance is unacceptable? So, ethics comes first, and a holistic approach to the ethics matter as well. So anything secretive is excluded by the company, be it anti-corruption, be it antitrust, and that kind of a reflex is being penetrated so that you don't get into a vicious circle or a cycle. And these violations typically require some form of duality. So it's very difficult for you to engage in these kinds of violations all alone, meaning that if you can break the chain of trust And if you can make sure that the chain of trust is between the company and the employees understand that the company sincerely expects ethical performance from them. So this is not just a charade. They have to issue this kind of a guideline, but then, secretly, by way of giving us these targets, they fully know that for us to be able to meet these targets, we would have to violate competition laws, kind of things. And then that asymmetry can be dealt with quite well. One very, very important thing in my view is that during these in-person trainings, and I was happy to see that in the choices it was said in-person trainings. During these in-person trainings, one has to explain that the company really expects compliance on the merits. So this is not a charade. This is not something that has to be done regularly so that we show the regulators in the future. And when I say to you, your WhatsApp messages can also be reviewed by the regulator, what I mean to say is not that do it, but don't do it through WhatsApp. What I'm trying to say is, just comply, and compliance on the merits is what we want. And so that the WhatsApp medium is also a medium that we as a company are interested in as well. We could discuss these matters as well. Some companies are excluding the WhatsApp channel entirely because it's too quick and the language used there is too easy to pull here and there. So it's more difficult to have a disciplined conduct in WhatsApp and what have you. But to the extent, especially in these days of pandemic, those kinds of quick communication means have to be used, be it Microsoft Teams or be it WhatsApp or what have you, Skype maybe. It will have to be known by the employees that it is the content of the correspondences that the company is interested in, and cosmetics is not what the company is after. That's the compliance culture, basically. Sometimes some guidelines look a little bit too much geared toward cosmetics. What is it that a reviewer would understand? There are even products that are being sold to that end, which any independent attorney, I would say, will have to fight against. For example, there are buzzwords counters. There are products that actually look into email messages and blink for buzzwords. Whenever this comes to me, I honestly get terrorized because all it says is just work around this term, this vocabulary, so that when an agency throws in this kind of a keyword, you don't get caught. It doesn't teach anything. It doesn't ensure compliance. It's just making life more difficult for the agencies. So that kind of a mindset is not going to go a long way, obviously.
Turning to a couple of the nuts and bolts now, and we'll only address a few of them given the time that we have, but two that I think are particularly important are, doing risk assessments and internal investigations, and then training, which everybody identified, well, not everybody, but a large number of people identified as a really key element of compliance programs. So, Gönenç, what are your views on when and how to conduct risk assessments and how to manage the scope of doing an internal investigation?
The scoping of an internal investigation is really a very tricky and interesting topic. And there is obviously an inevitable conflict of interest there. So as the specialist of competition law, as outside counsel, the client comes to you. And yet by defining the scope, you are also voting on the monetary side, the legal fee side of things as well. So an outside counsel working with a well-learned in-house lawyer is way more comforted, obviously, in this kind of a project, which is more generally the story at your part of the world. But in some countries, emerging markets, also in Turkey, sometimes you're directly dealing with the general manager or the CFO, so it's more difficult as to why you're recommending to cast a wider net in the instance at hand. Also, I think it is well possible that the company may start showing symptoms of too much of protest during the internal investigation. If it's in the form of resistance, there's no problem. That's something that can be handled by the outside counsel very easily. But if it is in the form of the internal investigation turning into a prompter of all kinds of whistleblowing and a prompter of all kinds of cries into the engaged internal investigation, then it's difficult to wrap up the existing internal investigation. And it does happen, especially if the antitrust matter is something that is being looked into carefully by the top. But there are other irregularities, other issues, mobbing allegations, customs law problems, other irregularities, anti-corruption matters that are actually bottled up in the entity. Suddenly they may start jumping into your investigation as well, at least in this part of the world. So what does this all mean? What this means is that the scope and depth of the internal investigation will need to be determined very well. The outside counsel and the in-house counsel will have to avoid any appearance that the internal investigation is muffling something or is escaping from some Pandora's boxes. They don't want to touch some cans of worms. It is courageous, but at the same time, you're not basically in the business of getting richer and richer on a perpetual, never-ending internal investigation. This is truly a tricky field, especially when you are dealing with clients that are not so experienced with these compliance projects. Email reviews may turn into big deal issues. Looking into WhatsApp correspondences may become big issues. Sometimes even the professionals may be finding themselves in difficult situations, in the sense that after the separation of the employee, we have seen instances where the employee has moved against the attorneys, saying they have stolen this data, or that there was no proper consent for this, which can obviously means that in these kinds of instances, the outside counsel will have to be extra careful. A board of directors' decisions will have to be adopted. Powers of attorney specific for this task will need to be given, so that if the attorney has to explain in the future that this was fully authorized and the consent is in there, then there's no issue vis-a-vis a public prosecutor, which sometimes we have seen as an issue in the past. There is also nice guidance about all of this in some of the work that the OECD has done. The ICC has done good work on this. So how to scope and how to conduct. And sometimes these kinds of tools are not universally applicable. Like when we discuss these things in the ICN, for example, the more sophisticated regimes have a different approach to it, and there's better traction in there. And the emerging markets attorneys would find themselves a little bit at a loss, because it's an uphill battle. But those toolkits and those instruments, I think, do work, and those guidelines are quite helpful. I also include the July 2019 guideline of the Department of Justice in there, in terms of how to evaluate the criminal compliance programs in general.
But what we see is a lot of that enforcement activity taking place at some of the highest parts of the organization. Very senior leaders are being embroiled in those kinds of investigations. So I think that highlights the need to revisit your risk assessment as things change. And then obviously there's the issue of, when do you do an internal investigation? Do you wait to kind of have some issue bubble up and then do the investigation? Or do you invest some resources and kind of periodically go around and identify whether there are particular groups of the company that may be high risk, and do an investigation at some level of detail, just to kind of check in on how effective the culture of compliance is filtering down to people who are going to create problems for you.
These periodical checks sometimes really help, and that was part of your question. Sorry, I omitted that. So we do use this with a couple of clients because we know that in a given year, for 2-3 months of that year, their activity is going to be 5-6 times more than their activity in the rest of the year. For example, the client is producing and distributing spirits and alcohol beverages, for example. And over the months of June, July, and August, it goes crazy and everyone wants to sell. And then come September, we're waiting for next May, June, July, the summer period. So then if you were to announce that every September, I'm going to review your June, July, August practice, it really helps. And the expectation of that control keeps them in control. Because if you dilute it as a program that may or may not have tests and checks over the course of a whole year, really, when it comes to be the crunch time, they feel now's not the time to think about those kinds of things, and they go forward. But if you really plant in September, there's this game theoretic situation of them already being on notice that they will be checked in September, and it helps, we find.
So Gönenç, on training, which is a bit of a focus and an area of interest for people, what kinds of training have you seen be most effective?
So if it turns into too much of a monologue, I find, regardless of how engaging the trainer is, it doesn't stick, it doesn't stay. So there has to be more of an interaction. Modules are quite useful, and testing, definitely. So questions and answers, and keeping it tailor-made as well. The worst kind is the Antitrust 101 kind. So basically, it's not even tailor-made. It's not, talking about the industry that the counterpart is in. They can't relate to what is being told. The examples are, coming from very different industries, and they're just trying to apply it to what their business life tells them. I generally find that, that there was a period of time when we were doing those kinds of trainings as well. But now decades have passed, and now I think doing it tailor-made and bringing in comments is very helpful. If we have the luxury of doing the following, that, in my view, is the most effective, but it requires resources, obviously. A training that follows some form of electronic review that we have already done. So we've always seen that suddenly the entities realize that this is actually happening to them. So this is not a theoretical thing. The person sitting next to you has written this email, and here is either the misunderstanding that could come out of it, or it's not a misunderstanding, this is a problem, we need to remedy this problem. Typically in those kinds of trainings, we take out the names, last names of individuals who have sent the email message and try to anonymize that a little bit, because otherwise it turns into after you show 4 or 5 slides, it's the minute you put the 6th slide, the entire room explodes into, Mr. Such and Such has also done something wrong, or it's too much of a caricature. They're like watching a ball game or something. So we try to keep it a little under control in terms of the sentiments, and have them focus on the fact that each and every single one of these is either a problem in terms of use of language, or worse yet, this is in and of itself an evidence of a wrongdoing. Those kinds of Trainings typically happen after we have done an internal investigation because of either a whistleblower activity or kind of periodical review that we always do anyway. The bad thing that can happen in that kind of an environment is that people may feel that they're under threat and that we might recommend that they get sacked. So they may try to not express their problems. They may escape with their issues. So if the company allows us to give them the comfort that we are a compliance team all together right now, and this is not an exercise of terminating people, then it's for the best. And we generally recommend that to the client. But some clients don't have that luxury because this may be the 5th time we're doing this kind of an exercise, and the upper management might be sick and tired of constantly having we're a team kind of an environment, in which case then they need to show that they mean business. So then we see that more and more we're speaking and they're just listening. That's not the ideal form, but it's still better than a generic training, we find.
Yeah, Gönenç, do you have any experience in, trying to conduct internal investigations and encountering this? I've come across it in the merger context, certainly, where, a second request, for example, may impact parts of the organization that are in different jurisdictions that have different privacy rules. And as Maria said, it does involve a dialogue with the agency about the limitations of what you can obtain. And then also a dialogue within the company to the extent that important individuals who may have evidence that's helpful, are encouraged to, give us consents and things like that to the extent that they're permitted under their local rules.
We're litigating these points quite heavily at the moment as well, because this has created quite a bit of tension between the Turkish Competition Authority and some of our clients. In some sectors where there are particular obligations to keep data private in financial sectors and what have you, the Turkish Competition Authority has sent out requests for information that is available outside of Turkey. And they have sent these requests to counterparts in Turkey, taking the position that, well, you're a subsidiary of that entity, so you deal with them and send us the data. And of course, this wasn't a proper way of legal service to the entity. The entity that actually held the data couldn't use this kind of a service to a subsidiary as a reason for compliance. So even if the entity outside of the country were to want to take the position that because I'm compelled lawfully by a regulator to provide this data, I'm now providing it and sending it overseas, because they never received the legal service adequately and fully, they couldn't comply with it. These were all data protection problems as well. Now, those litigations are still ongoing. These are very hot new developments in Turkey. Meanwhile, on the data protection side, one thing that we have observed more and more is that the employees are also flagging issues of data protection, especially when it comes to a contentious procedure. So once the for-cause termination or justified termination, as we call it in our labor law, happens, then the employees move, sometimes even against the attorneys. I personally have been to the Turkish High Criminal Court twice on these kinds of charges so far. So then you're upping your defensive game, obviously, and it's not enough that you have a power of attorney and an email message that requests this kind of a review. Now you're asking a board resolution. Then sometimes you just want to conduct this swiftly and without putting the employees on notice. And there's a tension there too. So if you were to ask for too many corporate governance documentation from the client, especially if there is a foreign entity that is instructing us to conduct a review on their subsidiary, and including the general manager and the board of directors members of the subsidiary in Turkey, then that's an issue of tension as well. Because from a criminal law perspective, obviously the view can be that these are two separate entities. And while there is a shareholding relationship between the two of them, one cannot give consent on behalf of the other one. So the fact that the outside counsel is retained by the affiliate outside of the country does not function as a consent on behalf of the subsidiary in Turkey. I don't mean to bore you with details, but I'm pretty sure that the exact same situation must be happening in quite a lot of jurisdictions. So there is this new area of defense and this new tension. And more regulators, I'm sure the Turkish Competition Authority would confirm this. And I know that the CAGI has the same kind of an experience, and the JFTC in another conference just voiced same kind of views. More and more regulators have been receiving resistance from their subjects, quote unquote, as to data protection. So they would move to get a data, and the response would come in as saying, hey, there's data protection. How am I going to get this data for you and provide this to you in a lawful manner? If it is in the same country, there's less of an issue. But if it is being requested from another country, there's typically a hierarchy between the jurisdictions as well. Getting data from a French company, I'm deliberately using the French example, a French company for a Turkish company, because the Turkish company is being subjected to a request, is almost impossible. And then the authority moves to come up with a daily administrative monetary fine. And the entity says, I really would comply if I could. I just can't get the data from them. And you don't want to jump through the hoops of legal service vis-a-vis them, so I don't know what to do.